Hello everyone. Today we are going to talk about res judicata, that is section 11 of the CPC. Res judicata has its origin in Latin language. This is a Latin term. What is this res judicata? The matter which is already decided and adjudicated by the court. When this res judicata applies, it applies when the matter already decided by the court between the same party, same matter cannot be filed in another court. If you want to apply res judicata, then these four components should be there. First is the same parties should be involved in the previous suit and in the further, that is next suit. If the same parties are involved in both suit, then the second suit which will be filed by the same parties would be barred by this section. Second is same matter should be in issue which is discussed distinctively. It means both the matters, both the suits which is filed in the court, the matter in the issue would be same. Then the another suit which is filed in the court will be barred by this section. The decision which is given in the previous suit should be decided by the competent court. It simply means the court should have the legal authority to decide the matter. It should have that particular jurisdiction to decide the matter. And fourth, but that is very important, that the court should give the final decision about that matter. It should not be interim, it should not be temporary, but should be the final decision. If you want to understand res judicata in more simpler way, then this example would definitely going to help you. In this example, let's assume that A files a suit against B regarding the ownership of the land. Now court decides that B is the owner of the particular land. Then the same ownership issue cannot be filed by the A against B. So this section 11 applies if B files the same issue again against B in the court. This res judicata simply helps to prevent the re-litigation in the country. Every section has its own purpose. Now let us understand that what is the purpose of this res judicata. First, it is important to prevent the litigation, that is multiplicity of the litigation in a country. It helps the state to avoid an increasing rate of the litigation. Second, it saves the court's time, which is very valuable when you see in the context of the Indian judiciary system. Already there are so many pending cases in a court, and that is one of the major issue and the challenges that Indian judiciary system is facing. Third is it protects the parties from the harassment, the wastage of money, and at the same time the valuable time of the court and of the individual should be avoided if the section res judicata applies correctly. Fourth is it ensures the finality in the litigation. Hence, all these four purposes are important to F2 for the Indian judiciary system to ensure justice would be served effectively and efficiently. Okay, bye.